In the 1999 Supreme Court case of Davis v. the Monroe County Board of Education in Georgia, Aurelia Davis sued the school district on behalf of her fifth-grade daughter, LaShonda. Davis claimed that the school knew of her daughter's sexual abuse and failed to stop it. The abuse was continuous and severe across several months from 1992 through 1993. LaShonda repeatedly complained to her teachers, and each time the teachers did nothing. She asked to move seats, she asked to be separated on the playground, and each time the teacher either denied the request or ignored the situation. In 1993, the mother brought charges against her assaulter of sexual battery, to which he pled guilty. As a result of the abuse, LaShonda's grades fell, and she began writing suicide letters. Aurelia Davis filed the suit in 1994 against the school district, requesting compensation for LaShonda's pain and suffering. Davis sought to hold the school district accountable for the neglect against her daughter. The first court case was filed in 1994 to the Federal Court of Georgia. The court dismissed it on the grounds that the school could not be held liable for student-on-student harassment. But that did not stop Aurelia Davis. She appealed her court to the 11th Circuit Court of Appeals, where once again the case was dismissed, citing the same reasons as before. The school could not be held liable for student-on-student harassment or abuse. The court case made its way to the United States Supreme Court in January of 1999. The Supreme Court found in a 5-4 favor of the Davises, citing that school boards are liable when officials are deliberately indifferent to sexual harassment, of which they have actual knowledge, that the harassment is so severe, pervasive, and objectively offensive that it can be said to deprive the victims of access to educational opportunities or benefits provided by the school under Title IX. The biggest impact of this ruling was that it held teachers and administrators accountable. Teachers can no longer just ignore a situation and hope that the kids will grow out of it. The school cannot ignore harassment in the hopes that the children will work it out themselves. It is the responsibility of the school to take decisive and direct action in all cases brought to their attention, and to create a safe and welcoming space that is free from discrimination as outlined in Title IX of the United States Constitution. For anyone seeking more information, the entire Davis v. Monroe Supreme Court case is recorded on oes.org. You can read or listen to the trial transcripts. You can also go through all of the evidence and documentation that was provided at the time of the trial. Thank you.